dispatched to a Best Buy in Houston, Harris County, Texas, in regards to a theft. The call notes advised that the suspects had left the location in a red Dodge Challenger with a temporary tag that started with 74. The officer located a vehicle consistent with the description about 0.8 miles from the business. The officer was also given a description of the suspects. A traffic stop was initiated. The officer immediately recognized Defendant Sauceda from previous thefts from Best Buy. Defendant Sauceda stated he took 2 items from the Best Buy without paying. The passenger, who is identified by her Texas driver's license as Defendant Ayala, and Defendant Sauceda entered the store and went to a cell phone station. Defendant Ayala distracted the cell phone employee while Defendant Sauceda used a pair of scissors to remove 2 cell phones and exit the store. Shortly after, Defendant Ayala received a text message from Defendant Sauceda, and she immediately left the store without purchasing any items. The total value was $1,499.99, and the 2 items were located inside the vehicle.
Ms. Ayala, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now ordering you not to have any contact with the co-defendant in this case. If I find that you do, I will revoke your bond, put you in jail. No more PR bonds. I'm also ordering you and barring you from going to any Best Buy in anywhere. Do you understand? If I find that you pick up a new case, if I find that you violate these conditions, that's it.
Yes, sir.
So do you mind filing those conditions, no contact with the co-defendant, no going to any Best Buy, anywhere? And then now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you, I will issue a warrant for your arrest. For now, I'll have you sign a reset with Victoria. We'll have you take your seat in the jury box. So we'll get your bond condition. We'll have you sign it. And after that, you'll be free to go. Okay, thanks.
Judge, I have 2 bond violations. The first one is Torres Noe. His bond violation is for failing to show up to a random UA. I tried reaching out to him, Judge. Apparently, he got deported. So that kind of explains why he's.
Sure about that? How do you know?
That's what the family told my office.
Got it. Okay, I'm gonna end up revoking it then, because I can't just leave it open. I'll leave it at 2501.
Yes, Judge.
Okay.
And then you reinstate if he's got.
I mean, let's see, but more than likely, like if it's not his fault, they just up and took him, then, you know.
Yeah, his family says he was detained by ICE and deported.
Just I would reach out to the family, let them know, hey, if you're gonna get him back, do it the right way.
Yeah.
You know, like get permission first, and then if I see that they do that, then of course, absolutely, I would reinstate it. So
Sure.
who's second?
And then, Judge, the second one is gonna be Lemberg, John.
With an L.
Yes, Judge.
Come up, Ms. Lemberg.
And Judge, I spoke with Mr. Lemberg. He had a BAC of 0.03 on his interlock. I spoke with him about the incident. We talked about, let's just be honest about this and let you address it. We are asking for an admonishment because it is his first bond violation. He said he went out with friends on Friday, had some to drink. He didn't drive that night, but the following day he didn't know that he was going to be positive when he tried starting the car, and of course the ignition interlock picked on it. I did admonish him that your bond conditions are no drugs, no alcohol whatsoever. It's not only when you're driving, but throughout the pendency of the case. He understands that now. He is just asking if you would give him an opportunity to change.
You had a WI 2 years ago. Now you've got another one. We tell you not to consume alcohol, yet it's happening anyways. So either you don't care about court orders or you have a problem.
Yes, Judge.
Have you seen how many people we put in custody?
Yes.
I'm now going to put a monitor on your ankle so I know that you're not consuming at all. I'm going to put a SCRAM monitor that detects alcohol through your perspiration 24 hours a day, 7 days a week. I don't give a rat's behind what your next excuse is. If I find that you ever test positive for anything else again, I will lock you up. No more PR bonds. Do you understand?
Yes, Your Honor.
Your other ankle, I'm now going to put a GPS monitor and I'm going to give you a curfew of 9 p.m. to 6 a.m. If I find that you're out because I don't want you out in the middle of the night, likewise, you will go into custody. Do you understand?
Yes, Your Honor.
It is absolute no tolerance hereforth. I don't care what your excuse is from now on. No means no. Do you understand?
Sir.
Okay?
Thank you, Judge. May we be excused?
Yes, ma'am.
Thank you.
Good morning, Mr. Villasana.
Morning.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 7th, 2025, at approximately 7 p.m., officers were dispatched to a person in town on the West Digital Road in Harris County, Texas. The officers spoke with the witness, who was the witness stated that the defendant was parked when he got to the location and was asleep in his motor vehicle. The vehicle was turned on with all doors were off. The witness stated that he knocked on the window multiple times to see if the defendant wakes up, that the defendant did not respond to knocking, and that the witness had used a special tool to open the door and was finally able to get the defendant and seemed a little bit off. The witness stated that the defendant had told him that he had been drinking a few hours prior to driving to the gas station, and that he observed a brisk man in the middle of the car, asked the defendant about it. The witness stated that the defendant had been in the hospital 3 days ago for alcohol problems. And another witness stated that multiple customers had stated that the defendant had been parked at the gas station. And when that gas station made access to witness to the cameras and saw the defendant's car had been parked there since 6:30. Witness 2 went outside to check on the defendant, and the defendant was asleep and tried to wake up the defendant by knocking on the door, but he did not wake up. The motor vehicle was on. The officer observed a strong odor of an alcoholic beverage, poor balance, and disorientation. He refused SFSTs and admitted to consuming alcohol a few hours prior. An open container of Jim Beam bottle was locked in a hidden compartment of the passenger seat, and an empty can of Four Loko was located in the center console. A styrofoam cup with a lid and a cup holder with a liquid matching the color of the liquid in that Jim Beam bottle was also found. The DIC was read and the defendant refused breath. The blood warrant was signed and executed and was identified by his Texas driver's license.
Are you telling me that he had alcohol in the car while driving?
Yes, Your Honor.
Mr. Villasana, I'm going to find that there's probable cause to go forward with the case. I'm now ordering you not to drive any vehicle whatsoever for any reason. Do you understand?
Yes, sir.
If I find that you do, I can have a contempt hearing. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also ordering you to obtain a portable device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol. If you have a problem with alcohol or illegal substances, you better address it. Because if you don't, and it becomes a problem, I'm going to do it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, Your Honor.
I am sending notice to DPS and I'm placing a restriction on your license that you are not allowed to drive any vehicle that doesn't have an interlock on it. I'm sending notice now to DPS in Austin so that every police officer in this state knows that if you're caught driving a vehicle and that vehicle doesn't have an interlock, they will take you to jail. Because I'm ordering you not to drive now, that's why I'm giving you a portable device. But do not drive. Do you understand?
Yes, sir.
You get no more warnings. If I find that you do, I'm going to lose it. Do you have the ability to hire lawyers, sir?
Sir.
Okay, we will give you time to go hire a lawyer. I'm going to have you swear to us that you're not going to drive. I will get you to Victoria where we will have you sign a receipt. You will get with Felicia if your bond conditions. After that, you're free to go. Be careful, Mr. Villasana. Okay. You are Alejandro Castillo.
Yes,
Mr. Castillo, you're charged with failure to stop and give information. Essentially leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
No.
On March sixth,
Sí,
twenty twenty-five,
2025,
at 9
Señor
a.m.
de la mañana,
Officers were dispatched
oficial
to a crash at a
fue
location in
localizado en
Texas.
el condado de Las Vegas.
Upon arrival,
Al
the officer
llegar,
met
los
the
oficiales
complainant.
se el quejante.
The complainant stated that she was sitting at a red
Estaba
light
en
and she
el
was
rojo
struck
cuando
by the defendant, and then the defendant
el
left the
demandado
scene.
huyó de la zona.
The complainant was
El
able to
demandante
get the
pudo
vehicle's license plate.
tener la licencia.
The
La
complainant
placa
followed
de
the defendant through a
lo
residential
siguió a
neighborhood
la
where the
vecindad
defendant lost control
residencial
of the
donde perdió
vehicle
el
and
control
crashed
del
into a
vehículo
house
y
about a
él
mile from the
se estrelló
original
con la
crash.
casa.
The
En el auto del
complainant
quejante
estimated damage to be around
los daños sobre
$2,500.
los
It is not $100.
That's what I was gonna ask you. Okay. Mr. Castillo,
Señor Castillo me dijo,
I'm going to find that there's sufficient probable cause to go forward with the case. I don't know what your immigration status is, but if you're not in this country with permission
permiso.
and you go to jail, and immigration finds you in the jail because they sweep it every single day, every couple hours. If they find you in there, they will place an immigration detainer on you, and you will be stuck like Chuck in there until this case is over with. And then you will be shipped off to immigration where you will sit. It takes 9 months just to get a 911 tape here, so you will sit for that time, then shipped off to immigration. I don't know what your status is, but if you're not here with permission, you better live with a halo over your head and not violate any conditions that I put on you now. I'm ordering you not to drive. You do not have a Texas driver license. You do not have liability insurance. You are not to drive. I don't care what is going on in your life. I don't care that you need groceries. I don't care that a baby needs to go to the hospital. If you don't have a Texas driver license and liability insurance and approval from us, you are not allowed to drive. If I find that you break this condition, your bond goes bye-bye. You have the ability to hire a lawyer.
¿Ocupar su propio abogado? ¿Usted puede ocupar su propio abogado si vamos? No. No.
I can have you fill out an application and I will take a look to see whether you qualify for an appointed lawyer. I need to know everything about you. We are filing conditions that you're not to drive. Do not leave until you sign our bond conditions. Deputy Miranda is now going to give you an application for an appointed lawyer. I will have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box, sir.
Was that financial affidavit?
Yeah. Good morning, Mr. Reyes.
Good morning, Your Honor.
Always a pleasure.
Nice to see you, Judge. Same here, sir. Look sharp, Judge.
You're Miss Grab?
Yes, good morning.
Good morning, ma'am. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 9th, 2025, at approximately 1:08 a.m., an officer observed a vehicle on the 5,000 block of Westlow Road, Harris County, Texas, speeding going 58 miles per hour in a 40-mile-per-hour zone. This was confirmed by Dr. Rear. The officer followed the vehicle and observed the vehicle to fail to maintain a single lane several times. A traffic stop was initiated. The vehicle did not initially stop. The officer initiated sirens, at which point the defendant's vehicle increased in speed and continued to fail to maintain a single lane and failed to signal lane changes to get around another vehicle as the officer was in pursuit. The vehicle finally came to a stop. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed the defendant to have red bloodshot eyes, thick slurred speech, and the strong odor of an alcoholic beverage upon her breath. The defendant admitted to coming from a wine bar and said she had 2 glasses of wine. SFSTs were conducted. 6 out of 6 clues observed on the HGN, 5 out of 8 clues observed on the walk and turn, 3 out of 4 clues observed on the one-leg stand. The DIC was read, and the defendant consented to a breath test. The results were .100 and .101.
You said she was going 50 speeding or 40?
58 miles per hour and 40 miles per hour.
Got it. Okay. All right. Ms. Grab, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Sure.
You have a lawyer. He will take care of you. Because you do, I will waive your appearance. Just stay in touch with him and he'll tell you if and when you have to come back to court. For now, we'll have you go to Victoria, sign a reset. Oh, does she have a license?
Yes.
No prior DWIs?
No priority WX.
Okay, we'll have you sign a reset, Victoria. You're not allowed to drive unless you have valid liability insurance as well. If you don't have car insurance, do not drive. That is a condition of your bond as well. Do you understand?
Yes, sir.
Okay, I'll have you sign a reset, Victoria. You'll get with police of your bond conditions and you're free to go.
Thank you.
Take care.
John C. Joseph, it's my understanding that you want to talk to him and see why he didn't appear in court on his last court date.
So this is basically an arraignment.
Yes, sir. I understand that we were going to do it as an arraignment.
He's been AWOL. It's now 400 days, 350 days old. Mr. Joseph, you're charged with 2 cases. You're charged with burglary of a motor vehicle. You're charged with unlawful carrying of a weapon. Your cases are now 352 days old. It's time to decide what we're going to do. Do you have offers on these cases?
No, sir, we're still waiting for the security video.
We do have an offer, but yes, we are waiting on the security
I
video.
need you to get on it
Absolutely.
like yesterday.
Yes.
I'm ready to set this case for trial. Way too much trauma, and I'm not gonna just.
Yes.
Mr. Joseph, I'm now going to put an ankle monitor so I know where you are at all times. If I find that you have one on now, you take off on me again, I'm gonna make your bonds extremely high. Do you understand? I will
Yes,
give
sir.
you a big flight risk and the bonds will go very high. At some point, someone's gonna stop ponying up all this money. You're just giving free money to bonding companies every time you take off, man. That's all you do. On your burglary case, you're not to have any contact with the complaining witness in these cases. You're not to be in possession of weapons.
Did you say you already have something going
Yeah.
from, is it from Harris County?
Mm-hmm. I turned myself in the other day and they ain't doing nothing better.
Don't say anything. I don't want you to say something. Perhaps the magistrate put it on.
I don't see any magistrate conditions, but
He's got 2 cases. Look at the other one, please.
and here of them were supervising an ankle monitoring order. We had one on him back in April of last year, but we haven't been supervising it since June due to the warrant.
All right, I want to go back to the original bond conditions that had a curfew with the monitor on now. No alcohol, no dope. What do you do with yourself these days, Mr. Johnson? Mr. Joseph?
I just started looking for a job. No, sir. I just started looking for one, filling the application.
I'm going to bring you back in 2 weeks. I want to see what you have done to get a job. Did you graduate from high school?
No, sir.
That's what we're going to also work on as well. I want to see what you've done to start working on your GED as well. I'm giving you 2 weeks. If you've not done anything, it's not going to go well for you. Do you understand?
Yes, sir.
Okay. All right, Mr. D, we'll give you a couple weeks, but I want him back in 2 weeks here to see what we've done to either get a job or get his GED.
Yes, sir.
Okay, if nothing, then it's not going to go well.
Yes, sir.
All right. Hi, Vic. What's up? What's new, man? Good to see you.
Good to see you.
Happy Friday.
Happy Friday.
You mean
I'm gonna do a PSI on it rather than fully upstairs, so it's made my Friday a lot better.
scary though?
It is.
No, let me tell you, I did a PSI once where I was basically going to get probation
Yeah.
and then got smacked with 25.
And it did enhancement. I'm Vaughn, and it's working, and it's got a lot of support. And it's a really silly case. It's a silly case. It's evading arrest, but it's,
I trust you.
yeah.
You know, you're the best, but PSI, it's just,
There's always risk there, but the state was at 15, so.
yeah.
Melgar, Daniel Melgar, this is my fault, Judge, PTI packet, he had to do with it yesterday
Okay.
to Abigail and
Well, not to Judge Geis, right?
Yes.
Okay.
I think
Everything's submitted?
Everything's submitted, all the discovery is turned over. The point was 6, so it's just a little bit above the cutoff. I think he will get.
Why? So were you denied?
We were told to submit a mitigation packet, yeah.
Okay, so it wasn't a denial and then you appealed,
Correct, correct.
right? They just submitted a mitigation package.
Resubmit mitigation
Got
packet.
it. All right, we'll give you a week.
Sounds good, Judge.
Hopefully we can have a decision within a week.
I hope
If no
so.
decision is made, I will waive the appearance. We'll give them a little bit more time.
Okay,
If it's approved, your guys got to be here so we can send it for a T-Res.
okay,
Okay?
sounds good.
Yes.
And then we'll just come back. Hopefully they got it within a week to make the decision or not.
Sir,
Yeah.
it's good.
Okay.
Judge, thank you. Nice to meet you.
Good luck, Vic.
Thank you, sir.
Are you on probation or parole at this time?
No.
You were on parole in 22. Is that over now?
Yeah.
Okay. So I don't show any holds on you now.
Is there no hold?
I don't see any. Do you guys? You guys? Yeah, we don't see any holds. But if you continue with what this has happened and this keeps happening, the sentences just get longer, longer, and longer. All of it self-control, Mr. Kaufman. You're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 15 days in jail with credit for the 7 days that you've done. You need to understand that this is going to go on your record. From now on, you're facing a minimum of 90 days in jail. Do you understand? So Lori, the trespass is being dismissed.
Are y'all dismissing the trespass?
Believe so, yes, Your Honor.
There is a trespass, right?
Here's a trespass. Was there plea paperwork for the trespass?
So they're going to dismiss the other case that you got. But like I said, you're still facing a minimum of 90 days in the future. So you pick up another case, it's just going to be a long time. You understand?
So I got time served.
Yeah.
Yes.
Yeah. But if you want something, if you need something, we have services for you. If you need a place to sleep, you need food to eat, we got you. All you got to do is ask. But this, you're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal, Mr. Kaufman. So once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do? How do you plead to the offense, sir? Guilty or not guilty? I'm going to find you guilty. I'll send you to it. Good luck, sir. Thanks a lot.
Judge, can I start with Alator Aristelsi for bond violation? She tested positive on 3/4 on March 4th for cocaine, Judge.
Can you bring her up, please?
And Judge, this is her first bond violation. If you'd be willing to give.
Ordered you not to use, you're now testing positive for cocaine. That's unacceptable. No, I'm not going to let you go. Marijuana, alcohol. No, you're testing positive cocaine. Unacceptable. I order you not to use. Now I have to take further action to ensure that you're not using. First, I'm going to revoke your bond. You go into custody.
Judge, would you allow her to do a walkthrough bond?
No. I need you to realize that we mean business, that when we tell you not to use, especially cocaine, you're not to use. I'm sorry.
Would you set on that, Judge?
$5,001.
5,001. And Judge, I have two more. I have Enrique Flores.
Enrique Flores, come up.
And Judge, on this one, he was in lockout since March 6th. He missed a recalibration appointment. He was working in San Antonio. He does construction work. He didn't know he had that recalibration appointment. He's no longer in lockout. And so I think it was just an issue. He did not know he had that recalibration appointment, Judge.
This is not a burst bond violation with him missing.
I think it might be the second, Judge.
Judge, yes, it's the second. The first one was for the same thing.
Take your time, no rush. Deputy, ain't you going? We need your help. No? Did we let him go the first time?
Yes, Judge.
We didn't take him into custody the first time?
No, Judge.
Unacceptable. He now goes with you. No?
What would you set his bond at, Judge? 5,000?
What's the last name again?
Flores, Judge?
Yeah, 5,002.
5,000?
Yes.
All right, Judge, and I have one more, and it's Gomez.
Okay. Jorge Gomez, come up.
So Judge, he did take a drug test today because he had failed to report for a drug test on February 21st, and he tested positive for marijuana.
You see how many people we've taken into custody? I ordered you not to use, and you're now testing positive. If I find that you ever test positive again, I will put you in jail. Do you understand? When I say don't use, I absolutely mean it. You will get tested in 50 days. If I find that you continue to use, into jail you will go. Do you understand?
Yes, Your Honor.
Yes. Absolutely no tolerance here for it. And the next time you miss an appointment, likewise, you will go to jail.
Yes, Your Honor.
Thank you, Judge. In 50 days, Judge?
Yeah, reset 50 days must appear.
Okay, thank you, Judge. Thank you, Judge.
All right, so Mr. McGee, you've worked out an incredible, well, not you, your lawyer has worked out an incredible deal. You're charged with five, it's 5 open cases, right? Shh. You're charged with evading arrest, failure to identify oneself, evading arrest, theft, burglary of a motor vehicle. And As part of the agreement, you're going to plead guilty to the burglary of a motor vehicle and the evading arrest. You need to understand that both of these cases are enhanceable cases, meaning if you pick up another one of these cases, it's very possible they charge you with a felony offense. Now, on the burglary case, it may be 2 or 3. I think it's a third, it's a felony. But on the evading case, you pick up a second one, you're looking at a felony charge, years instead of days. You understand? So I don't know who you're hanging out with. I don't know what you got going on in your life, but you got to surround yourself with better people, because you start the wrong people, they're going to bring you down. Don't become another statistic. We have enough Black and brown people in custody now. Don't become a statistic. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you plead guilty to these cases. You can't do anything else. It goes on your record. It'll be there forever. How do you plead to both cases guilty? Mr. McGee, if you need anything, just come back, talk to me. I'll get you whatever you need. If you want a place to stay, food, cell phone, tablet, we can work just about anything to get you what you need. It's never a problem.
Yes, sir.
But would you get out there, you get on the street, you got to be careful, man. You get one life. You don't get another one. There's no redos. Good luck, man. Yes. It's 30 days, I'm sorry, 30 days in jail, credit for the 29 and 31.
Okay.
It's Tyron, whatever you'd like.
So we can, maybe we
I don't
can.
know about a bond is because it's kind of.
Yeah, no,
It's a free time.
we don't.
Oh, got it.
And maybe we can review PC. I think we're in agreement with the trespass. There was no trespass for the.
I'm always happy to hear PC. Let's do it.
Yeah.
Jay, you want to do it or no?
Let's do it.
Okay.
All right.
What's the contract reference?
255-4294.
It's on document.
Oh, it is?
Yeah.
Sorry,
please.
Okay. On March 4th, 2025, at approximately 10:30 a.m., officers were conducting an investigation for an evading case at Oyo Hotel. The officer made contact with the manager of the hotel, who showed surveillance video that showed a male who had been given several trespass warnings and stated he refused to leave and comes back all the time. The suspect was a black male with a jean jacket and dreads. There is also a posted no trespassing affidavit on the front of the hotel. The officer spotted the male and attempted to make contact with him. The officer approached the defendant and the defendant began walking away, and the officer advised him to stop. The officer placed his hand on the defendant's arm and the defendant began running down the stairs carrying his bicycle. While running, the defendant used his bicycle as a barrier and shoved it towards the officer, hitting his left knee. The defendant continued to run around the motel, and he grabbed his bicycle, which he left on the left side of the building, and the officer was able to take the defendant into custody after a taser was used. The defendant was identified by his Georgia ID card. The defendant has an open probation violation warrant out of Louisiana for a weapon charge.
So he's at a hotel.
Yeah,
Was he, you're saying he's not allowed to be there.
correct.
Are you saying he was?
There's no trespass warrant on file with his name on it. I believe there's a homeless encampment near this hotel, off Highway 6. And so a lot of the homeless people go back and forth. Mr. McGee is homeless. I don't know. It's not clear whether Mr. McGee is the person that they're referring to. I know he's a black male with dreads, but he's never received a trespass affidavit. And there's no information of that.
You said that there was one.
It says in the DIMS that the complainant pointed out the defendant on surveillance video and said, I have told him several times, I've given him several trespass warnings and he refuses to leave and he comes back all the time. And then also it
Maybe
is
they were
stated in the
verbal.
DIMS that there's a trespass affidavit posted on the front of the hotel.
Okay, but that doesn't mean anything. That just means like no trespassing.
And usually with
It's
the
like,
trespass affidavits, he was there visiting someone that stays there. So in all of the loitering with convenience stores and things of that nature, that applies to people that are there without any kind of, if you're not buying anything, visiting anyone. So he was visiting one of the people that was staying there. And that's why he had his bicycle. The police, I basically just grabbed him and he was coming down the stairs. So I don't think we have a valid trespassing case because there's no affidavit with his name on it. And if he was there legally visiting someone at the hotel.
is a verbal trespass warning sufficient?
I would disagree, Your Honor, especially because this is, and I guess we would need to see what their trespass affidavit says, because usually the ones at the convenience stores, I've dealt with this a lot. It excludes people that are there legally.
I mean, I get that the penal code doesn't say that it has to be in writing.
Mhm.
You know, I mean, it could say, hey, I don't want you here. Don't come here anymore.
Mhm.
So
But then if we take that blatantly, that there's a trespass affidavit, then that means.
but then
that-
anybody could say,
That's correct.
right, I get it.
wouldn't
I
be
get
able to
it.
Go in and visit my aunt. She was staying at that hotel, so it can't be that restricted. If he was there with his bicycle, he wasn't just out in the front visiting someone, he was up inside of the hotel with his bicycle coming down. He was there visiting someone. So I don't think that there's any information or evidence that says that.
So the state would concede that a general trespass affidavit would not be enough. So it would be due to the verbal trespass warnings that were given to him several times by the manager and him refusing to leave the location.
So where do we go from here? Like, how are we gonna?
My goal is, Judge, or my hope is that the state, in looking at this and knowing that he has a case out of New Orleans, which he's on parole on, I'm hoping that they will resolve these issues. I have spoken with his parole officer, and he, bond or not, he is going to have to sit in jail another 14 days to be extradited. But because he's on parole, I cannot plead to anything because I want him to get to New Orleans and have the ability to potentially get terminated.
They're coming, obviously, right?
They are, it's a,
But it's Louisiana, so they should be here.
it'll be pretty fast.
I mean,
think the larger part of it, it's not Louisiana jail, it's not the Richardson Parish jail, this is a parole violation. I think what council is saying is that for whatever they contend for the parole violation, they're gonna have it before the board. It'll obviously, if he takes a conviction, that's gonna affect his eligibility versus a dismissal.
But there was already a warrant regardless.
Right.
Something happened regardless. So perhaps he absconded or
Because he had been here homeless off the grid, so he had no residence and things like that. And so that's why. But for conviction here.
right. The only problem, Ms. Sparks, is that the 14 days or any time it's told,
As long as this is going on.
because he's not made, you know,
Yeah,
One of them, I think one of them can be bought.
I'm showing both their,
yeah, no,
he's not made bond on
we
either.
were
of them.
told it made no sense to me.
If I may, last Friday, we revoked the bond on the local cases to keep Louisiana from coming to get him.
Oh,
Oh, that's this one?
I don't remember
Yes.
that. I didn't remember that. I thought it was someone else that we.
Yeah.
Okay, so,
So that way you wouldn't have to go back and forth and deal with the same.
right, you're right, you're right. No, she's right, because the problem is that if they come and get him, he goes over there, then a hold gets placed on the exact same situation. So
I trust Blaze, and his staff.
guys,
Stand down.
whatever you want to do, if you want to set it maybe just a couple days to look further to see if there is anything, if you could probably perhaps somehow get that he's actually visiting someone.
Yes, Your Honor.
No.
Okay, yes, Your Honor, I'll stand down.
Yeah.
Okay,
I didn't
pause.
remember
The
that. I
officer
thought it
spotting
was
this
someone
car
else
8
that
miles
we-
out is
Yeah.
wildly
Okay.
fast police work.
So,
So that way you wouldn't have to
But
go
here's
back
the
and
real
forth and
question
deal with
for
the
you.
same.
Right.
If the
You're
suspect's
right,
already
you're right.
dipped from the
She's
store,
right, because the
should this
problem
still
is
count
that
as an easy probable cause
if they
stop?
come and get him, he goes
Spoiler,
over there.
yes, because matching car
a
plus
hold gets
matching
placed on
tag
these,
plus fresh
the
theft
exact
call
same
equals a legal
situation.
green
So,
light.
I trust Blaze,
Let me know
and
in the
his staff.
comments
Guys,
whether you think the
stand
officer
down.
would have pulled
Whatever
them
you want to
over
do,
even
if you
without
want
the
to set it
prior
maybe
theft
just a couple
history.
days to look further.